Judge. Just briefly, after Ms. P.V. Hall stepped down from the witness stand, she indicated to our office that she had not, in fact, received a subpoena from the defense.
Okay.
And was asking if she would be able to come into the courtroom to observe things. Told her we'd have to talk with the court about that.
Okay. Any response? Did you think you subpoenaed her, or do you have any other information?
Sure. Well, I do want to be candid with the court. If I could call the office, I would have known I would have called the office to confirm. But if I could call the office, I could let you know. We have tracking on all this.
Okay, that would be great. Can you do that right now?
Absolutely.
All right, thank you.
And there's one other thing, Your Honor.
Hold on, Mr. Cruz. Don't go anywhere. Yes.
Sorry. Our next witness is in a wheelchair.
Okay.
We're going to get her. She's confident she can get up in that witness stand, but I would ask that we do that before the jury comes out. I think it would just be better.
Well, sure. I don't have any problem with that, but I do want to make sure that this is a person that can't. Are you suggesting that this person can get out of the wheelchair and climb up the steps?
She told me she can.
Well, I don't know that that's necessarily necessary. I mean, she can certainly testify in front of the witness stand and things of that nature. I mean, I really don't want anyone to risk getting hurt.
100% agreed, Your Honor. Again, I also asked her if she would be willing to testify from the floor or not.
Okay.
She said she could do it. So.
I'll let you handle that, but I have no problem with her being next to the bench with the microphone.
Thank you, Your Honor.
All right. Go ahead, sir. All right, we're going to go back on the record. Mr. Cruz?
Yes, ma'am. So so for certain witnesses, the state asked us to send the subpoenas to them based on witnesses saying, or they're exercising the statutory right not to be contacted by the defense. I had a different interpretation of the statute, but I also wanted to fall in line just in case, just to err on the side of caution. So what we did, we sent a subpoena to Ms. Ashley P.V. Hall. We sent it to 3467 Ridge Mill Circle, Dacula, Georgia. I believe that's the information that we have. But also, just to cover both bases, we also sent a copy to the state, and the state said that.
Since those two individuals have elected not to be contacted by the defense and are victims in this case, or family members of the victim who are entitled to protection under Marcy's law, that we would accept service on their behalf. We never said that about Ms. P.V. Hall or Dr. Lowe.
Okay. And Mr. Yelmanchili, can you tell the court what it is that Ms. P.V. Hall said to you about the subpoena?
This is second-hand, Your Honor. I'll just preface it by saying that. But she, after she left the courtroom or on her way out of the courtroom talking with some of the members of our victim witness assistance team, that she had not received a subpoena from the defense, and therefore she was wondering if she was able to come into the courtroom to view the proceedings.
All right. Thank you. Mr. Cruz, anything else, sir?
We could send down a court the tracking information if the court would like, just to perfect the record.
All right. Thank you. Mr. Yelmanchili, I'm going to ask you to ask your victim witness advocates to get the information from Ms. P.V. Hall as exactly what she understands about this whole subpoena issue. If she relays to your staff and then relays to you, which will relay to the court, that she has not received a subpoena from the defense, she may be in the courtroom. So that'll be the order. All right. You may go ahead and call your next witness. Yes, sir. You can go ahead, Mr. You all may be seated. Thank you. All right, welcome back, ladies and gentlemen. We are back on the record. Mr. Bolden, you may call your next witness.
Thank you, Your Honor. Ma'am, I'm going to ask you, well, you got a battery pack in your right hand. Maybe, can you raise your right hand?
Yeah.
Okay, there we go. Ma'am, do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. And I'm going to ask you, please, to state your name and spell it for the court reporter, please.
Marla Lawson, Marla-Lawson.
And Ms. Lawson, I want to talk to you a little bit about your career. Can you tell this jury what you have done for a living, ma'am?
Oh, gosh. Well, I started out in 1970s at the Atlanta Police, at underground Atlanta, and was a street artist, and they hired me on the Atlanta Police Department as a typist. So I typed reports mostly, and then word got out around the bureau that there's a girl downstairs who can draw a face. So, I mean, that's about the way it went. I started drawing the faces of perps and everything else for the detectives. And stayed there for about, 20 years.
Okay. Did you then go on to draw faces for Coweta County?
Yes, sir. I drew them for Coweta. Well, heck, I drew for everybody. The whole time I'm, just working. Coweta County, Cobb County, most of the cities.
Did you spend about 16 years as I'm sorry, I didn't mean to do that. Doing forensic sketches of. Did you spend about 16 years doing forensic sketches or for the Georgia Bureau of Investigation?
Yes, sir.
Can you talk a little bit about your training and background as it relates to forensic sketch artistry?
Well, I don't really have any background or any training. I just kind of picked up a pencil and went to town. And after I did that, I wound up doing it for almost 20 years. I don't know. I just always have fallen into the right job for whatever somebody needed.
Your Honor, can you turn the Elmo off? Thank you. While you were working as a sketch artist, did you attend courses
Yes, sir.
related to that?
Yeah, I took all the courses that there were at the, trying to think where. All the courses that they offered, at the.
I tell you what, Ms. Lawson, I'll move on. Did you ever win any awards for your forensic sketches?
Yes, sir. But the most public display of awards was for Eric Rudolph, because when the Olympic Park bombs went off, they called me, and I go over there to draw his face, and he was relatively famous, I guess you'd say.
So I understand, did you draw a forensic sketch related to the 1996 Atlanta Olympic
Yes, sir.
bombing?
And most high-profile cases in between, they would call me. I mean, I was at GBI, but
You would work for other agencies?
yes.
I got you. Okay. Over the course of your career, do you have any idea how many forensic drawings you would have completed?
Good Lord. No, I would estimate 1,000.
Have you ever been asked to come into court and testify about your sketches before?
Yes, sir.
Yeah, have any idea how many times?
Probably no.
Ms. Lawson, I want to talk a little bit about the process of creating a composite drawing.
Okay.
And so kind of walk through that with me. How do you first meet with the individual that you're questioning and then go through that process if you can?
Okay. The detectives interview the witnesses and the victims and everybody, and they bring them to me, and I would show them a big, huge stack of old mugshots and photos of suspects and just old photos that I have in a big case that I dragged from pillar to post way back when. And I would tell them as they're looking at the photos, pick out anything that reminds them of the person, eyes, nose, shape of the face, teeth, hair, anything, pull it to the side and we would talk about it. And the average person would probably pull out 15 photos, and I would just draw it together into one face and hold it up, and they would help me change everything on it until we get it as far looking like the person that they remember, as they could. And I get them to rate it when we're done on a scale of 1 to 10. And as far as 10 being him and 1 not. So we just make corrections along the way, and
How long does this process take on average?
it probably takes 45 minutes per person.
And you mentioned kind of the ranking at the end. Is there a number by which you say, okay, like we're going to stop, or can you kind of describe that for me?
Yeah, I tell them to pick out a number between 1 and 10 as far as it looking like the person that we sketched. And they usually pull out, I guess, 3 photos for that too, By this time that I've got them accustomed to digging through the photos. And we try not to quit working on the sketch until at least we get an 8 on a scale of 1 to 10.
By that, I mean, if the person were to give you a impression or a number that was less than 8, you would keep working. Is that fair to say?
Yeah, because in my opinion, anything below an 8, it's not worth circulating. But anything above an 8 or an 8 is a pretty good recollection of their memory.
Ms. Lawson, as you sit here today, do you have any recollection about coming to Athens-Clarke County to assist in an investigation back in January of 2001?
No. Yes, I do. I don't remember drawing the 3 composites that I supposedly had to draw, but
Have you had a chance to look at them, though?
I haven't even seen them.
Okay. Well, I'm just going to, if I can approach you.
Okay.
Ms. Lawson, we've got States 99 and States 100. States 99.
Uh-huh.
And what I want to point out there, ma'am, is do you recognize what's on the lapel of this individual?
Yes, sir.
What's
That's
that?
my
I
name.
got you. And then on States 100, I didn't see one there.
Well, you get busy and you get in a hurry, and
Okay.
You might not get them signed, or you might get them signed. I mean, you know, I'm kind of haphazard.
All right, give me just 1 second, Ms. Lawson. I want to make sure I didn't miss anything. Ma'am, I don't have any further questions for you. Defense counsel may have some questions. Thank you, ma'am.
Mr. Cruz, cross-examination.
Yes, ma'am.
Good morning, Ms. Lawson. How are you? I'm doing okay, Ms. Lawson. I'm maintaining. I thank you for being here today. I just have a couple of questions for you, if that's okay. All right. I'd like to show you a couple of composite sketches that you did in relation to sightings in this case. I'm going to mark those exhibits as Defense Exhibit 23 and Defense Exhibit 24.
I do have an objection to these exhibits, Your Honor. It's under 401 and 403.
All right. Let me ask you this question, Mr. Bolden. Do you have an objection to the admission of those exhibits? Okay. All right. I'm going to let you get started, and if you choose to try to tender them, I will hear your objection.
Yes, ma'am. Thank you. Ms. Lawson, do you recall completing sketches on Friday, January 26, 2001? Yes. Okay. I'd like to show you, and would you recognize those sketches if you saw them? Yes. Okay. I'd like to show you two sketches. And let the record reflect that I've shown Ms. Lawson Defense Exhibit 23 and Defense Exhibit 24. Do you recognize Defense Exhibit 23 and Defense Exhibit 24?
Yes, sir.
Okay, and these are sketches that you did for Athens-Clarke County on January 26, 2001?
They appear to be.
Yes, ma'am. Do they appear to be altered in any way?
They don't look like it, do they?
No, ma'am, not to my knowledge. Your Honor, I would move to admit Defense Exhibit 23 and 24, and I can respond to the state's relevance objection.
Right.
I do have an objection under both 401 and 403.
All right. Do you care to elaborate?
Yes, Your Honor. Well, one, none of the witnesses that would have potentially given a description to Ms. Lawson have been in court and testified. I mean, I do think we need to address some of this outside the presence of the jury.
All right, we will do that then. Ladies and gentlemen, I'll have you go sit in the jury room. Don't discuss the case. We'll be with you shortly. And while the jury is leaving, I'm just going to say for the audience, there are a number of people in here who may not have been here yesterday, so I want to make sure everybody understands the court's rule about cell phones. With the exception of the media, who has permission to have cell phones, with the exception, of course, of counsel and their staff, and with the exception of law enforcement and attorneys who are working in this building today, with those exceptions, everyone else is not permitted to have their cell phone out and in use. So if you have a cell phone, just make sure it's tucked away and turned off, obviously. We don't want it going off. Thank you very much. All right, you all may be seated. Go ahead, Mr. Bolden.
Your Honor, what Mr. Cruz is attempting to introduce through Ms. Lawson, she did provide, I mean, I'm not denying that those are sketches that she made at Athens-Clarke County Police Department back in January of 2001 in relation to this case. What I would say, Your Honor, is that those sketches are from witnesses who describe seeing an individual in Deer Park days before January the 19th. I mean, that is, like, if Mr. Cruz asserts otherwise, he's mistaken. So these are not relevant. And so not only are they not relevant, any potential, just, the fact that there were people that came to the police department and that gave descriptions to Ms. Lawson on that day in connection with this case is relevant under 401. And I think that the state's argument would really stop there. But even if there was some sort of probative value of that evidence, that it would be substantially outweighed by the risk of confusing the jury, because at this point we don't know who gave those descriptions and things like that. So these are not admissible in the state's view under both 401 and 403.
All right, Mr. Cruz, any response?
Yes, ma'am. Under OCGA Section 24-4-401, the term relevant evidence means evidence having, and I emphasize the language any, or the word any, but any tendency to make the existence of a fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And as the Honorable Court is aware, the threshold for relevant evidence is extremely low. The relevance of these photographs are that, the relevance of these photographs is that law enforcement, when they were speaking to individuals in the neighborhood, the individuals that they requested sketches of, as the Honorable Court is aware from the other states' exhibits, are any African-American individuals that were seen either the day of the crime or the day before the crime. I believe, I'll say this, and Mr. Bowden has something to counter that, but one was December 18th, which I believe is, not December, please forgive me, January 18th, which was the day before the murder, but law enforcement found it relevant, and Ms. Lawson completed a sketch. The other one was an individual they did see in this one on January 19th. So the evidence is relevant to the issue of, on one hand, we have a young lady saying, hey, I see a guy running. She tells law enforcement that. No sketches requested of that individual. However, law enforcement did request sketches of African-American individuals that were seen the day before, as well as African-American individuals that were seen not even at the scene, but the day of the fire taking place. Those are the individuals that they chose. So that's in response to the relevance objection by the state. And I know sometimes I confuse my words. Did I explain that wrong to the Honorable Court? Did I confuse the Honorable Court in any way?
I'm not confused.
Yes, ma'am. In regards to confusing the jury, I made it clear in my opening that law enforcement dropped the ball a couple of times, and this is a part of that. We have law enforcement getting sketches from January 18th. We have law enforcement getting sketches from a person, I think he was at the corner of Cooper Road, which is this individual, and Fawn Drive. But yet we have a young lady who explained to law enforcement that, hey, I saw this guy running, and law enforcement did not ask Ms. Lawson or that individual to complete a sketch. So that would be my response to the 401 objection, as well as the 403 objection, Your Honor.
All right, thank you, Mr. Cruz. Yes, sir.
So I would also point out, Your Honor, that the state did file a motion, SOTI motion is what we've been referring to it as throughout all the pretrial hearings and as we've gotten into the case. And, the law is very clear that Mr. Cruz has to proffer that in advance for exactly this moment. The only person he identified in that SOTI motion was Chris Melton. So, and the whole purpose of that is for the court to be able to undergo a preliminary 403 analysis. I cited the cases to the court. I just remind Your Honor, among those being the Crumpton case out of the 11th Circuit. And so there is a substantial risk. Any probative value is substantially outweighed. And I'm not saying that there isn't probative value, to be very clear, Your Honor. But any arguable probative value is substantially outweighed by the risk of confusing this jury, and I just don't think it's admissible.
Thank you. Anything further, Mr. Cruz?
No, ma'am, I stand by my argument in regards to the 401 objection as well as the 403 objection.
Thank you. All right. With regard to this offer of these two sketches, at this moment in time, I don't find them to be relevant.
Yes, ma'am.
The evidence has been described as being related to a sighting of someone not on the date in question, and also the other one not in the vicinity of the incident in question. So I'm going to grant your motion. I will say this: should the evidence, as it goes forward, tend to establish relevancy, we can revisit this issue. But for now, I'm going to grant your motion. I do also find, in granting your motion, Mr. Bolden, that you have made a proper argument over 403. I think at this point, given the description, Mr. Cruz, that you have provided about where those two sketches came from, it is certainly falls under the description in 403 of confusion of the issues. And so I'm going to grant your motion at this time.
May I ask the Honorable Court, I know we have Court's Exhibit 1, which was the PowerPoint. I don't know if the Honorable Court issued a ruling on that, but which was the PowerPoint from the state. I asked the Honorable Court to admit as Court's Exhibit 1. Can we admit Defense 23 and 24 as Court's Exhibit 2 and Court's Exhibit 3 for the purposes of the record?
No.
Yes, ma'am.
All right. You may bring the jury out. Thank you.
I'm sorry.
Yes.
I just thought maybe the issue with Ms. Peavy Hall, we could address it now. Or do you
Go ahead. No, go ahead, since the jury's not here.
I'm not going to say the address again.
Sure.
On the record, and I don't think it went out on the broadcast, but I do want to let the court know that my understanding, after having spoken with our Director of Victim Services, is that that is the correct address for Ms. Peavy Hall, that she has not received a subpoena.
Right.
She began checking because she was notified by Dr. Lowe when Dr. Lowe received hers, but she is unaware of any subpoena that was mailed via, I guess, certified mail.
All right. Thank you. Mr. Cruz, any comment? You want to speak to the staff that Mr. Yalamanchili talked about?
I do not. As I mentioned to the Honorable Court, I think you made your ruling on the subpoena issue, which I would abide by, of course. I'll just I'll perfect the record with a copy of the certified tracking and return receipt information.
All right. Thank you, sir. You may certainly do that. I'm going to allow Ms. Ashley Peavy to remain in the courtroom if she chooses. All right. Will you bring the jury in, please? Thank you. You all may be seated. Mr. Cruz, you have the floor.
Thank you, Your Honor. Ms. Lawson, please forgive me. In regards to your process, I understand that you have them look at photographs, and from there they pick the shapes and different portions, eyes, things of that nature that fit the individual that they see. Is that correct? Okay, and I've had opportunity to look at the Eric Rudolph sketch. I'm sure you have because you've completed it. Typically when you complete sketches and they're on the 8 scale, as you mentioned, are they pretty much similar to the person's description, accurate to the description that you receive? Okay, excellent. Do you keep any notes in regards to those pertinent, or at that time, would you keep any notes in regards to the pertinent facial features that an individual described?
I fill out incident reports of each composite drawing that I do, and will sometimes, state whether or not I had any problems or anything was said about, when we were complete and should they circulate it or whatever. Did they feel good about it? And that's why, how we determined the completed, thing, sketch.
Absolutely. So there's I'd like to show you a document. I ask for your patience for a second. I'd like to show you a document that I am going to mark as Defense Exhibit 25. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 25. Okay if I approach you, Ms. Lawson?
Yeah, come on. Okay. Yeah.
All right, in regards to Defense Exhibit 25, is that the document that you're speaking of when you say report, or is it a separate document?
That's the document.
This is the document. Okay, excellent. Your Honor, please forgive me. You recognize this document, correct?
Yes, sir.
Okay, and is it a fair and accurate depiction of the document as you remember creating it?
Yes, sir.
Okay, and does it appear, outside of the Defendant's Exhibit sticker, does it appear to be altered in any way?
No.
Okay. Your Honor, I would move to admit Defense Exhibit 25 into evidence.
Any objection?
Generally, no. I think that based on the court's ruling just a few minutes ago, parts of it would have to be redacted. So
All right.
subject to that redaction, I don't have any objection.
All right, Mr. Cruz, you want to be heard on Mr. Bolden's comment on the redaction?
Yes, I do. Court's indulgence. Let me make sure I'm 100% clear on
Sure.
that. In regards to the state's objection, I do believe, based on your prior ruling, I would not be able to admit that evidence. So I don't have any objection.
All right, so I just want to make sure we're clear that state doesn't have any objection over the admission except for certain portions that need to be redacted based on my ruling, and you agree with that?
I don't agree, but I respect
You're not
the
objecting to
position.
that?
Correct, yes,
Okay.
ma'am.
All right.
And I just want to be clear because what I think I heard, and correct me if I'm wrong, is that he's now not intending to tender the document?
No, that's incorrect. I do intend to tender the document, Your Honor.
But you're not objecting to the comment, the argument that Mr. Bolden made about certain portions need to be redacted according to the ruling the court has made?
Correct.
All right, then I will admit it with that understanding, and it can't be certainly circulated to the jury until I take a look at that document and we all agree what needs to be redacted. But I will admit it. Go ahead.
So in regards to, and I may need to give you this, in regards to suspect number 1, the composite reconstruction notes, would you agree that you put that the male was black? Is that fair? He was 18 through 21 years of age.
If you could just answer with your voice, yes or no?
Yes.
Thank you very much.
Thank you. He has an orange shirt. Is that correct?
Yes,
Medium brown complexion. Is that right?
yes,
Short 2-inch afro. Is that correct?
yes.
I need to ask you a question about something personal, John.
Nay.
Yes.
And slight mustache. Is that correct?
That's right.
Okay. And I'd like to show you what has been marked as defense, state exhibit 99. With the description that we put in our report, which exhibit does that description apply to?
I don't know.
That's fair.
Either suspect 1 or 2, but I should have wrote it legibly across the top maybe, so this long gone of a time period could have figured out who was who.
Yes, ma'am. In regards to Ms. Tiffany Riker, and I'm going to show you what's been marked as defense exhibit 25, okay?
Okay.
In regards to Ms. Tiffany Riker, we don't have a description that she provided. Is that correct?
Let me see if I wrote anything down. No, but the suspect 2 was listed.
Your Honor, this is what we're getting into. Like, state's objection was sustained as to portions of that document needing to be redacted, and now Ms. Lawson's being questioned about the parts to be redacted.
All right, let me see counsel to the bench with the exhibit, please. Well, it has actually been admitted, but 25 has been admitted. Yes, Mr. Bolden. It's been admitted. I'll certainly let you now use the redacted, according to the court's ruling, Exhibit 25. You may proceed.
Ms. Lawson, please forgive me. All right. Excluding the redacted portion. In regards to this Tiffany Riker, in regards to your description of Ms. Tiffany Riker, would you agree that we don't have a description of the composite sketch completed for Ms. Riker?
I don't see it, but yeah.
Yes, ma'am. And in regards to the 1 through 10 scale On the document, Defense Exhibit 25, we don't have a notation of whether it was a 8, 9, or 10.
No. Sometimes I just don't, I don't write it on the originals because nobody knows what it means.
That's fair.
I guess I should have written it on there. I'm just accustomed to being fly by night, I guess.
It's okay.
Take that back.
Yeah.
I'd also like to show you what I am marking as Defense Exhibit 27. And let the record reflect that I am showing the state what has been marked as Defense Exhibit 27. Let the record reflect that I am showing the witness what has been marked as Defense Exhibit 27. May I ask you some questions about Defense Exhibit 27? Do you recognize Defense Exhibit 27?
Yeah. It's one of my old ones.
And what do you recognize Defense Exhibit 27 as?
Well, homicide, arson, and what we drew,
Is it,
posits, you know.
yes, ma'am. Is it fair that is it fair to label it as a summary of the work that you were doing in regards to the date and who asked you to come in?
Yes.
Okay. Outside of the defendant's exhibit sticker, has it been altered in any way? And that is a fair and accurate description of the document as you remember it.
Yeah.
Thank you. I would move to admit Defense Exhibit 27 into evidence.
I do have an objection under 401 and 403 to the entirety of that document.
All right. You want to be heard outside the presence of the jury.
I think it's probably necessary, Your Honor.
All right, ladies and gentlemen, if you're going to the jury room, don't discuss the case. We'll be with you shortly. And we are taking a lunch break relatively soon. Please be seated. Are your objections, Mr. Bolin?
Yes, Your Honor. So what Mr. Cruz is attempting to introduce here is basically just a cover sheet of Ms. Lawson's report. And I don't see how that has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable. She's already testified to her kind of notes relating to how she generated the sketch. And I with the relevant or irrelevant portions redacted, I don't see any issue there. But now we're getting into the cover sheet of that report, and I just fail to see how that makes the determination of anything more or less probable. The witnesses have both testified that they recognize the sketch. They have been admitted. And I just, again, I don't see why that would pass 401 muster. I would also say that whatever conceivable relevant or probative value that Mr. Cruz might argue is once again substantially outweighed by the risk of confusing the jury, because there's reference to these other suspects, which we all agree, or he doesn't agree, but which I have asked the court, and the court sustained my objection relevant to that, is also on that cover sheet as well. So again, first of all, under 401, it's not relevant. Second of all, under 403, whatever relevance it has is substantially outweighed by the risk of confusing the jury.
All right, thank you. Mr. Cruz.
Sure. So in regards to the state's 401 argument, relevance, the relevance of this document is twofold. One, the testimony has shown that these individuals saw 3 different people walking through the Deer Park neighborhood. Okay. Ms. Lawson stated during her testimony that the date that she spoke with these individuals was January 26, 2001. So that testimony has been elicited. It's also in this document as well, just stating on Friday, January 26, forensic artist Lawson traveled to the Athens-Clarke County Police Department, so on and so forth. So that's one. Secondly, Your Honor, I believe based on, and this is not an evidence, but just for the purposes of speaking to the Honorable Court, I believe her sketches are very accurate. I looked at the Eric Rudolph sketch. I believe the individuals in those sketches are the individuals that gave the information saw. So I'm just putting in place that she did it on February 26th, and to bolster the, and I know it may be the wrong word, but to bolster the accuracy of the sketches. That's all, Your Honor.
Okay, well, that's an improper use of, evidence. First of all, bolster is probably not the word you needed to use.
Correct.
I agree with you on that.
Support the
I know what
accuracy.
you're saying, but
Yes, ma'am.
bolstering is not
Inadmissible.
proper use of it. But I guess, can I see the exhibit? I'm
Yes,
not
ma'am.
really sure what we're talking about.
May I approach?
Yes, of course. Thank you.
And if I could add, it's a memorialization of the date that she conducted those sketches.
Thank you. Mr. Cruz, can you respond to Mr. Bolden's argument that the reason that 403 is implicated is
Sure.
the reference to, I'm assuming you're saying, the phrase composite sketches of 3 suspects. Is that what you're referring to, Mr. Bolden?
Yes, and I think it is, I'm sorry, Your Honor.
And composite sketches of the suspects. I mean,
3
is that what you're saying?
suspects.
Okay.
Says
Okay.
the word suspects, plural, is mentioned twice in this document.
Okay. And you're saying because there were only 2 witnesses who have been identified as producing testimony to this witness to produce sketches, that the 3 suspects violates 403.
Correct.
All right. Okay. I just want to make sure I understood your argument. Can you respond to that, Mr. Cruz?
Sure. Which portion of 403 are we? Do I need to address?
Well, I would say in general, certainly, but I mean, the state's argument to the court was that it was confusion of the issues.
Sure.
And that was substantially outweighed by.
Sure. Goes without, as the Honorable Court is aware, the issue that the jury has to decide is whether or not Mr. Faust is guilty of the charges in the indictment.
I know that, but with regard to that specific argument on this document about the 3 suspects, can you tailor your argument to that?
Sure.
Right.
It's general. We have stated that there were 3 different individuals, actually 4. The state's evidence, they introduced Mr. Matt Owens yesterday. He said he saw a black male with a white shirt and jeans. They introduced evidence from Ms. Tiffany Schroeder. She gave a description of the individual that she saw as well. They also introduced evidence from Ms. Karen Williams. She gave a description of the individual that she saw. So we do actually have three. We have four, but I'll stop at those three. We do have three individuals that have stated that they saw a black male walking in the neighborhood. And we can also add four with the witness that came in today and mentioned the individual that he saw walking down the street as well. So I don't think it would confuse the jury because they've already heard evidence of multiple individuals in the neighborhood, Your Honor.
All right, thank you. All right, so that gives me a better explanation of where you are coming from, Mr. Cruz. So this is sort of a two-part moment. The state's argument that this violates 403, I think, is accurate. I'm going to grant your motion because it's in relation to this witness. Regardless of what you've just mentioned, and I will talk about that because
Yes,
I don't mean to suggest that is, I don't mean to be flippant in that way, but
Yes,
I want to talk about your specific argument. With regard to this witness has been identified as the person who made the two sketches that are in evidence, And so the state's argument that this cover letter, and I don't find it to be relevant, but regarding 403, the state's argument that this cover letter violates 403 is appropriate because it refers to three different sketches. It, in this particular moment with this witness, does certainly create confusion of the issues.
Yes, ma'am.
I am not prohibiting you from discussing the testimony in the way that you have just described it. You have described the four witnesses that the state has presented talking about a person they saw in the neighborhood as being four different suspects. The state may choose to refer to those witnesses' testimony differently. But I'm not prohibiting you from talking about those, the comments that the witnesses have made in court about the person that they saw in the way that you've just described.
Yes, ma'am.
But with regard to this witness and this exhibit, I am going to sustain your objection.
Your Honor,
I'm going to grant your motion, sustain your objection.
Yes, ma'am.
Those reasons.
Your Honor, for the purpose of the appellate record, would the Honorable Court be willing to admit this as court's exhibit? I believe that would be 4.
I don't think that's appropriate, Mr. Cruz. I'm not
Yes,
going to do
ma'am.
that. All right, but I'm going to give this back to you. All right. Anything else before we bring the jury back in?
No, Your Honor.
All right. Mr. Cruz, you ready for the jury?
Yes, ma'am.
All right. Thank you. You may bring the jury back in. You all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Ms. Lawson, I want to thank you so much for your time. Those are all my questions.
Oh, thank you.
Thank you.
Any redirect, Mr. Bolden? May this witness be excused. Mr. Cruz, any objection?
No, ma'am.
All right. Thank you. You are excused from any further service. Mr. Bolden, did you care to call the next witness? Is this a witness that we can call and then take a lunch break?
We could, Your Honor.
All right. Very good.
Well,
Wait, just,
yeah, we can.
all right. We're going to do that. And who is your next witness that you care to call?
Kylie Traub?
Could you please get Kylie Traub?